boy!
You're lying!
Your heart is ugly and you disgust me. You are forever labeled a child molester, and everyone hates a child molester.
It was my daughter who was kicked.
In October 2017, Henry Lopez fell asleep while intoxicated with a lit cigarette inside his Rancho Bernardo condominium. The cigarette sparked a fire that quickly spread through the home. Lopez managed to escape but was unable to save his son Christos and daughter Isabella, who tragically lost their lives. Investigators later concluded that Lopez's combination of alcohol and negligence led to the devastating blaze, leaving both the family and community heartbroken. Lopez was charged and later convicted in 2019 of involuntary manslaughter, child endangerment, and reckless fire starting.
Have destroyed me. I could never get them back. Ever. Because of you. The dreams and nightmares are hell. Hell. Because I wake up and they're not there. His skin was on my hands. The smell. Henry Lopez, do you understand the smell of a burnt body? Of my little baby boy in my hand. He's barely breathing and I say let go and he lets go. I will never forgive you for what you've done to my children.
During sentencing in January 2020, family members, including his ex-wife, delivered emotional statements expressing frustration over his lack of responsibility.
You couldn't handle it, as you would say. Don't shake your head, you did.
You're lying!
I'm not lying.
How dare you lie?
How dare you? Oh,
How
let's
dare
go.
you lie?
Let's go. I have proof.
Ma'am, sir,
This is about the children.
sir.
I have to humble myself even more than before.
Accept the consequences for your actions, man. Okay? Accept the consequences, okay? Eat it. It happened on your watch.
Sir, stop.
Lopez showed no remorse, instead speaking about his personal achievements and desire for more daughters and sons, which further angered those present. The judge sentenced him to nearly 13 years in state prison, holding him accountable for the irreversible tragedy. In August 2021, Adam Thomas traveled from Sacramento to San Diego to visit his older brother, Trenton Thomas, who was living in a sober living home. Before the trip, prosecutors said Adam had purchased a crossbow and prepared for its use. After arriving, the two brothers spent time together, including going out to dinner. Later that evening, Adam led Trenton to a park in City Heights. There, according to prosecutors, Adam used the crossbow in an act that tragically resulted in his brother's death. Instead of calling for help, Adam left the scene, returned to his Airbnb, and eventually made his way back home. At trial, Adam's defense argued that the incident was not premeditated, but prosecutors presented evidence of his planning leading up to that day. The jury found him guilty of first-degree murder.
We'll never be able to fully explain the stress, anxiety, sleepless nights, empty seats at our Sunday family dinners. These events do and will haunt our family for generations to come. I'm asking for your help, not just for Adam, but for our entire family.
His family, while heartbroken over the loss, continued to support him and described the event as a tragic mistake. Adam was sentenced to 25 years to life in prison with the possibility of parole after 25 years, depending on future parole board decisions. In May 2020, 30-year-old Ashley Renee Williams was driving along San Pasqual Valley Road in Escondido when she lost control of her vehicle. She had inhaled computer duster spray and had both meth and marijuana in her system, while still on probation for a prior DUI. As she drove, her vehicle veered off the road and onto the sidewalk, where it struck a family out for a walk. The crash claimed the lives of Giovanni Felix, Emmanuel Riva, their grandmother, 50-year-old Carmela Camacho, and step-grandfather, 33-year-old Abel Valdez. The sudden loss devastated the family and left the community in mourning. Following her arrest, Williams pleaded guilty to 3 counts of second-degree murder and 1 count of gross vehicular manslaughter as part of a plea deal.
They were my everything. They were my life. Just to think that I will never ever be able to tuck my kids to sleep. That I will never ever have a conversation with my mom. I think one day I may forgive her. but I don't think I'm ready to do that now.
During sentencing, family members, friends, and even teachers spoke emotionally about the lives lost and the lasting impact of that night.
But as a teacher, I never thought I'd be in a courtroom where a former student, a current student.
One of the teachers read what other students of victim wrote in the yearbook about him.
He loved to draw. He always carried his sketchbooks. It still haunts me to this day. He just left a big mark on me.
The judge called her actions selfish and noted the pain caused by the tragedy. Williams was sentenced to 25 years in prison, far less than the 60 years she could have faced, and a permanent memorial now stands at the crash site to honor the victims. On November 6, 2019, 51-year-old Albert Lee Blake entered a Church's Chicken restaurant in Chula Vista, California, and attempted to make a purchase using a counterfeit bill. After being turned away by staff, Blake left the restaurant, retrieved a firearm from his car, changed his clothes, and returned through a side entrance. He opened fire, 28-year-old employee Maribel Marino Ibanez, and injuring 2 others. After the shooting, Blake fled California and traveled to Memphis, Tennessee. Authorities tracked him using surveillance footage, phone records, and evidence collected at the scene, eventually leading to his arrest later that month. Blake was charged with murder and multiple counts of attempted murder. During trial, prosecutors presented a detailed case, while victims' families shared emotional testimonies about the loss and trauma caused by the attack.
My wife's murder changed my life completely. My wife was a very good person. After that moment, he ended my happiness. And I want him to know that even if 100 years go by, it won't be enough time because I won't get my wife back. I'm a mother like many of you are, but he didn't think of that when he was every person, my daughters, especially how cruel he did shoot her until the end. He didn't stop to think it was my daughter he didn't do nothing to him to hurt her so bad. And I don't know how long it's gonna take.
The jury found Blake guilty, and the judge sentenced him to 146 years to life in prison, ensuring he will remain behind bars for the rest of his life. The courtroom heard powerful statements from the victims' loved ones, reflecting the lasting pain caused by the senseless act of violence. In February 2022, Kareem Mitchell, 38, a registered sex offender, and his wife, Sharice Mitchell, 51, were arrested in the Bronx for operating a sex trafficking ring. The couple, who lived together in a Bronx apartment, faced multiple charges, including sex trafficking and conspiracy. Among the 8 victims identified, 2 were foster girls placed in their care.
You were doing this with foster children? Is that correct?
A 9-month investigation uncovered evidence such as videos, text messages, financial records, and prostitution advertisements. These items revealed details about locations, including hotels and cars, where the acts allegedly occurred. Kareem Mitchell, a registered sex offender since 2008, had previously served a 5-year prison sentence. Despite his criminal record, Sharice had been approved as a foster parent, resulting in 2 young girls being placed in their home. She falsely claimed on her application that she did not reside with her husband, despite his registration at the same address. Evidence presented in court suggested that these girls had been coerced into prostitution after being recruited from the foster care system. The charges extended beyond New York, with related incidents reportedly occurring in Connecticut and New Jersey. Investigators revealed that threats and violence were used to control the victims, further highlighting the severity of the case. In June 2023, Kareem Mitchell was sentenced to 18 years in state prison after pleading guilty to multiple counts of sex trafficking. His wife, Sharice, received a 6-year sentence for her involvement. Women and girls were targeted through social media platforms like Facebook and forced into prostitution, with victims transported to various hotels as part of a sex trafficking operation. 7 people have been convicted for their involvement, with Brock Franklin identified as the leader of the ring.
I can't begin to even explain what he did to my life. 64 years just on what was done to me. That's a lot.
During the sentencing, one survivor addressed the court, sharing her feelings and finding solace in knowing Franklin was forced to listen to her words.
But reading it today and speaking and actually saying how I felt and him hearing and having to sit there and listen to me, that brought me so much joy, and that's why I came today.
The crimes were carried out in multiple hotels across the Denver metro area. While Franklin's defense argued for a reduced sentence of 96 years, the prosecution and survivors pushed for a stricter penalty. The court ultimately delivered the harsher sentence.
The 400-year sentence sends a strong message across the country that we're not going to tolerate this kind of violence to women and vulnerable populations.
Franklin received a 400-year prison sentence, the longest ever handed down for trafficking offenses in the country. This landmark punishment sends a clear message that such exploitation and abuse will not be tolerated. One survivor expressed that Franklin deserved every moment of his sentence. Brittany Zamora, a former 6th grade teacher, was sentenced to prison after being convicted of sexually abusing a boy from her classroom. The emotional court proceedings included statements from the boy's family, expressing their deep pain and anger at Zamora's actions. One family member directly addressed her, calling her heart ugly and stating that she had forever tarnished her reputation.
Brittany Zamora, you hurt my family. Your heart is ugly and you disgust me. Secret is out. The world knows you are. And while you sit in your cell and think that maybe things will get better, they won't. You are forever labeled a child molester, and everyone hates a child molester.
She would like to reach the podium, Your Honor. Certainly.
In court, Zamora apologized, pleading for a second chance and promising to reform.
I ask that you please have leniency in regard to my sentencing. I would do anything to re-enter society sooner for a second chance.
She admitted to abusing the boy, and prosecutors also highlighted disturbing details, including instances where another boy, a classmate, reportedly witnessed some of the abuse. Zamora described her actions as out of character and claimed she never intended to harm anyone.
My actions were completely out of character for me. As I stated earlier, I never want to hurt anyone, and it tears me apart to know that I have.
The judge imposed the minimum sentence allowed by law, citing the severity of the case. Zamora will serve 20 years behind bars without eligibility for early release.
They had a problem and failed to report that problem for reasons that we're going to find out.
The case also prompted a lawsuit against the school district where Zamora worked, alleging that the administration and principal failed to act despite knowing about issues involving her conduct. The district has denied any wrongdoing in court filings. In a heartbreaking case, 65-year-old Denise Brody passed away in April 2022 due to AIDS after living with undiagnosed HIV for at least 5 years. Initially believed to be suffering from cancer, Denise's true illness was revealed to her devastated family, who learned it stemmed from untreated HIV.
Then they end up calling us, telling us that she's not going to beat this. You need to take her off the ventilator and she's not going to make it. Because she has HIV, she has AIDS. She was in full-blown AIDS after having untreated, undiagnosed HIV.
Authorities allege that Denise contracted HIV from her husband, Cleveland Brody, who had been aware of his HIV-positive status since 2006, but failed to disclose it to her. Investigations and medical records indicated that Cleveland knowingly endangered Denise's life by hiding his condition and neglecting to take precautions. He was subsequently charged with felony reckless conduct of an HIV-infected person, a crime carrying a maximum sentence of 5 years per count.
Mr. Brody, you are charged at this time with the sole count of reckless conduct, HIV-infected person. It is a felony charge. Would you like the court to read your warrant aloud?
No, ma'am. Denise's family played a key role in uncovering the circumstances surrounding her illness, prompting the Rockdale County Sheriff's Office to open an investigation. During Cleveland's bond hearing, the family expressed relief when the court denied his bail, citing the risk of flight.
I am going to deny bond, finding you a risk of flight.
Investigators uncovered evidence of another victim and suspect there may be additional individuals affected by Cleveland's actions. Cleveland was charged with 3 counts of reckless conduct HIV-infected person. with each count carrying a potential 5-year prison sentence. In November 2023, a Rockdale County Superior Court judge set his bond at $1.5 million. If released on bond, Cleveland would be required to wear an ankle monitor and comply with a strict curfew. The Rockdale County District Attorney's Office has also indicated plans to pursue murder charges related to Denise's death. As of now, no final sentencing has been issued and legal proceedings remain ongoing. A woman accused of using sex as a means to lure men into dangerous situations and rob them has appeared in court to face multiple charges. In October 2024, 35-year-old LaCosta Marie Mortensen was charged with multiple counts of armed robbery in Pierce County, Washington. Authorities allege that she used the fetish website to connect with men, arranging meetings in Tacoma hotels under the pretense of engaging in consensual activities. She arranged hotel meetings where she would allegedly rob them.
The defendant is charged in 2 separate armed robberies in Tacoma and is listed as a suspect in a similar robbery that occurred in the city of Kent.
Police reports state that Mortensen carried a weapon during these incidents. She is accused of armed robberies in Tacoma and is also a suspect in a similar case in Kent. Court documents describe 2 specific incidents. In the first, which happened in September 2024, Mortensen reportedly robbed a military member, taking his wallet containing his ID and travel card. The second, in October 2024, involved her attempting to restrain a victim fleeing with his credit card, which she used to make purchases worth hundreds of dollars.
As soon as the defendant's charges are resolved in Pierce County, she will likely face charges in King County for the Kent robbery.
Evidence against Mortensen includes hotel surveillance footage, her phone number provided to victims, and body camera footage from an unrelated incident in July, which helped confirm her identity. In court, Mortensen pleaded not guilty, and the judge set her bail at $100,000. Additional charges in King County may follow after her Pierce County case is resolved. In April 2024, Ivy Millicent Jennings, also known as Mimi Morton, was arrested and charged with theft of property over $250,000. She allegedly embezzled approximately $650,000 from her employer while working as a personal assistant. Jennings reportedly used her employer's bank accounts and credit cards to make unauthorized purchases, including a $40,000 Lexus SUV titled under her business, Mimi Morton, LLC, and nearly $3,000 in items from various stores. In August 2024, a Shelby County grand jury indicted Jennings on charges of theft of property, $250,000 or more, and identity theft. She was released on a $60,000 bond.
Ms. Jennings, you understand these, you heard the conditions.
Yes, Your Honor.
In September 2024, Jennings failed to appear in court due to a high-risk pregnancy, as reported by her attorney. The court accepted this explanation, and she remained free on bond.
She does live in South Carolina. She's also a high-risk pregnancy at this time.
Jennings remains out on bond. There is no public record of a final sentencing, as legal proceedings are ongoing. Authorities uncovered a disturbing situation when they found 2 boys and a girl living in extremely poor conditions in a building on West Pine Avenue. The building, which had an attorney's office on one side, was being used as a makeshift residence by 24-year-old Christina Dickinson and her sons and daughter. When officers arrived, the boys and the girl were described as barely clothed, disheveled, malnourished, and hungry. They also showed signs of neglect and had been living without power or sufficient food for a prolonged period. The investigation began after a concerned family member reported the situation to the police. Dickinson was arrested and charged with child neglect. She insisted she wasn't a bad mother, expressed gratitude to the officers for what she called a wake-up call, and claimed they were her top priority. However, her actions raised further concerns when she requested a cigarette despite being pregnant. In court, her public defender argued that Dickinson lacked the financial resources to properly support her sons and daughter. The judge set her bond at $5,000 and issued an order prohibiting her from having any contact with them. The boys and the girl have since been placed with a family member, and the case has drawn attention to the struggles of families living in poverty and the importance of welfare interventions. In November 2018, 22-year-old Luis Alberto Virgen was driving a pickup truck along Interstate 8 near Boulevard, California, when he led U.S. Border Patrol agents on a high-speed pursuit. Virgen, who was transporting several passengers, continued to flee at speeds over 100 miles per hour despite law enforcement's attempts to stop him. As the chase continued in poor weather conditions, his vehicle lost control. The crash resulted in the tragic loss of 3 passengers and caused injuries to 7 others. Authorities later identified the passengers as individuals who had entered the country illegally, and the incident was classified as a human smuggling case. Following his arrest, Virgen pleaded guilty to multiple charges, including voluntary manslaughter and reckless driving causing injury. In February 2020, he was sentenced to 20 years and 8 months in state prison. Virgen will be required to serve the majority of his sentence before becoming eligible for release. On the evening of November 20th, 2018, firefighters responded to a house fire on Longwood Road in Mayfield Heights, Ohio. Inside the burning home, they found the bodies of 41-year-old Rebecca Pletnowski and her daughter, Olivia Schneider. Investigators quickly determined that the fire had been intentionally set. An autopsy revealed that Rebecca had been stabbed, while Olivia had died from smoke inhalation after being trapped in an upstairs bedroom. Authorities classified the case as a double homicide and arson. A week later, 20-year-old Dominique Swopes, who lived nearby, was arrested in connection with the crime. Prosecutors accused him of entering the home, killing Rebecca and Olivia, setting the house on fire to destroy evidence, and stealing several rings valued at over $1,000.
18 CRA 01182, State of Ohio, City of Mayfield Heights versus Dominique Swopes. Is that you, sir? Mr. Swopes, you're here for your felony initial appearance. You are charged with 2 counts of aggravated murder, 1 count of aggravated arson, and 1 count of receiving stolen property. It's alleged, sir, that in the City of Mayfield Heights on or about November 20th, 2018, that Dominique Swopes did purposely and with prior calculation and design caused the death of Olivia Schneider in violation of Ohio Revised Code 2901A. This is called aggravated murder. It's punishable by death or life in prison and a fine not to exceed $25,000. It's also alleged that on or about November 20th in the City of Mayfield Heights, Dominique Swopes did purposely and with prior calculation and design caused the death of Rebecca Pletnowski in violation of Ohio Revised Code 290301A. Also aggravated murder, punishable by death or life in prison, and a fine not to exceed $25,000. It's also alleged that on or about November 20th, 2018 in the City of Mayfield Heights, Dominique Swopes did by means of fire or explosion knowingly create a substantial risk of serious physical harm to Rebecca Pletnowski and Olivia Schneider in violation of Ohio Revised Code 2909.02 of the Revised Code. This is aggravated arson. It's punishable. It's a first-degree felony. It's punishable by 3 to 11 years in prison in annual increments and a fine not to exceed $20,000. Finally, Mr. Swopes, it's alleged that in the City of Mayfield Heights on or about November 20th, 2018, that you did receive, retain, or dispose of certain property, being 4 female rings valued at more than $1,000, the property of another, 1 Rebecca Pletnowski, the said Dominique Swopes, knowing or having reasonable cause to believe said property had been obtained through the commission of a theft offense. This is in violation of Ohio Revised Code 2913.51. It's called receiving stolen property. It's a felony of the 5th degree. It's punishable by 6 to 12 months in prison in monthly increments and a fine not to exceed $2,500. Do you understand the nature of the charges against you, sir?
Yes, sir.
Do you understand the potential punishments?
Yes, sir.
Okay. So, Mr. Swopes, I need to advise you that you do not need to make any statements today. Okay, and anything you do say can be used against you in future proceedings. Understood?
Yes, sir.
Okay. So, Mr. Swopes, yesterday you filled out a financial disclosure form. I had an opportunity to review it, and I found that you are indigent, and I appointed Timothy Sturkle to represent you. It's my understanding you've had an opportunity to meet with Mr. Sturkle on multiple occasions, correct?
Yes, sir.
Okay. And so you've had a chance to review the charges and read them with Mr. Sturkle?
Yes, sir.
Okay. Next, I need to advise you that you do have the right to a preliminary hearing. Okay? A preliminary hearing would be conducted before me. At that hearing, the burden would be on the City of Mayfield Heights to establish probable cause of two elements. First, that these offenses were committed, and second, that you are the individual that committed these offenses. Okay? If the city was able to establish each of those elements, your case would be bound over to the Cuyahoga County Court of Common Pleas for further felony proceedings. Understood?
Yes, sir.
Okay. Have you talked to your counsel about your right to a preliminary hearing?
Yes, sir, I did.
Okay. And Mr. Circle, at this time, does Mr. Swopes wish to waive his preliminary hearing, or does he wish to schedule a preliminary hearing?
Chairman, may it please the court, as you've indicated and Mr. Swopes indicated, I did speak with him yesterday at length. I spoke to him again this morning. Earlier, I spoke to him maybe 20 minutes ago. I reviewed with him, Your Honor, as you've indicated, the charges, potential penalties. I reviewed with him all the rights he enjoys under the criminal rules and the Ohio Revised Code. And based on that, Your Honor, it's my understanding that Mr. Swopes wishes to have a preliminary hearing and have that scheduled at the court's earliest convenience.
Okay. Is that correct, Mr. Swopes?
Yes, sir.
All right. This matter is going to be set for a preliminary hearing this upcoming Monday, December 3rd at 2 p.m. Does that work for you, Mr. Vintonio?
Yes, sir.
He was charged with 2 counts of aggravated murder, aggravated arson, and receiving stolen property. At his initial court appearance, Swopes was informed that the charges could carry a sentence of life in prison or the death penalty.
Mr. Sturkle, do you want to be heard on the issue of bond?
With Your Honor, I've had a chance to talk to my client about this. Based on the information I have, I don't believe he has any type of a record. Your Honor, we would just respectfully request that some type of reasonable bond be set in this matter. Thank you.
Thank you. Mr. Vintonio, on behalf of the City of Mayfield Heights.
Your Honor, the city would ask for at least $1 million bond. Thank you.
All right, thank you. All right. Based on the nature of the circumstances of the crime charge, bond will be set at $5 million. Is there anything further on behalf of Mr. Swopes?
No, Your Honor, I think that covers it. Thank you.
On behalf of the city?
No, Your Honor.
All right, we are adjourned.
The judge declared him indigent, appointed him legal counsel, and set bond at $5 million. Over the years, the case continued to develop. In October 2022, a Cuyahoga County grand jury returned a new 14-count indictment against Swopes, adding charges such as aggravated burglary, robbery, felonious assault, and tampering with evidence. Prosecutors indicated they were considering the death penalty. However, on March 2, 2023, Swopes entered a guilty plea to 2 counts of aggravated murder, 1 count of aggravated arson, and 1 count of aggravated burglary. As part of a plea deal, the death penalty was taken off the table. He was sentenced to life in prison with the possibility of parole after 40 years. On March 3, 2020, in Akron, Ohio, 19-year-old Sydney Powell was at home with her mother, Brenda Powell, when a tragic series of events unfolded. Brenda, a well-known employee at a hospital, had been on the phone with university staff discussing Sydney's academic status. In the middle of the call, loud banging sounds and Brenda's screams were heard before the call abruptly disconnected. Concerned, university staff contacted police. When officers arrived at the Powell residence, they found Brenda critically injured and Sydney holding a weapon, confused and disoriented. A skillet was also found nearby. Brenda was rushed to the hospital, but later died from multiple injuries. Sydney was hospitalized and later charged with 2 counts of murder, felonious assault, and tampering with evidence. During the following 3 years, Sydney was released on bond and complied fully with court orders, continuing mental health treatment without incident. At trial in September 2023, her defense argued that she was suffering from acute psychosis and could not comprehend her actions. Expert witnesses diagnosed her with schizophrenia or schizoaffective disorder. However, the prosecution maintained she was aware of what she was doing and presented digital evidence and expert testimony to support their case. The jury ultimately sided with the prosecution, and on September 20th, 2023, Sydney was convicted on all charges. During sentencing on October 30th, 2023, the courtroom was filled with emotion began as family members and supporters from both sides gathered. Despite the devastating loss of Brenda Powell, her family expressed continued love and support for Sydney. They submitted heartfelt letters to the court, urging compassion and emphasizing their belief that Sydney's actions were driven by untreated mental illness rather than malice. The defense supported this view, asking the judge to impose the minimum sentence and to recommend mental health care within the corrections system.
And I think when the court looks at the factors under 29-29-12 that determine whether or not this offense is less serious than the types of offense that get sentenced, there are a number of factors there that support a minimum sentence, namely that there was strong provocation by Sydney and that there are substantial grounds to mitigate Ms. Powell's conduct, although those grounds are not enough to constitute a defense. Obviously, this court heard from and the jury heard from 4 separate expert witnesses that the defense had brought forth, and although the jury did not feel that this rose to the level of not guilty by reason of insanity, I don't think that there's any dispute that, and the government said in its opening statement, and I believe closing arguments, that Sydney Powell's mental health had some impact on the consequences and the conduct in this case. So I think when considering those factors, this is less serious than some of the murders that Mr. Stano is trying to lump Sydney Powell and her family into. When the court considers whether or not Ms. Powell is less likely to, or is more likely to commit future offenses, I think nearly all of those factors weigh against the likelihood of any future offenses being committed. Ms. Powell has never been adjudicated delinquent as a juvenile. She has never been convicted of any previous offenses. She has never demonstrated a pattern of drug or alcohol abuse related to this offense, and I think she has shown genuine remorse. And I think that was borne out not only by the experts who testified, but also by Betsy Brown and Stephen Powell and others who testified who know Sydney well. When you look at the factors that determine whether or not an offense is less likely, an offender is less likely to commit a new offense, nearly all of those factors, I would suggest, apply here. And that is, prior to committing the offense, Sydney Powell had not been adjudicated a delinquent child. She had no prior criminal record. She led a law-abiding life up until this event. And there were the circumstances under which this event occurred, which is untreated serious mental disease, have been remedied. We know that Sydney Powell has been out on bond for 3.5 years. She has done better than perhaps any client I've ever had over 30 years as a criminal defense attorney while out on bond. You heard evidence that she never missed a dose of her medication. She looked forward to counseling. She abided by each and every one of this court's conditions that would keep her in the community. We never had any concerns or issues brought to this court by pretrial services regarding Sydney's behavior. And then lastly, under the factors that determine whether a consecutive sentence is warranted or necessary, I just do not believe respectfully that the law would support consecutive sentences that Mr. Stano is asking for. And those 3 factors are, number 1, to support a sentence of consecutive sentences, whether the offender committed one or more of the multiple offenses while the offender was awaiting trial or sentencing. That obviously is not present here. Whether 2 of the multiple offenses were committed as part of an additional course of conduct. This was all one course of conduct. I believe that's undisputed. And whether or not the offender's history or criminal conduct demonstrates that consecutive sentences are necessary. And then finally, I know that this court must also consider the wishes of Marcy's Law and the wishes of the victim, and they have been repeatedly ignored by Mr. Stano in this case. I think the court knows that. We had a hearing on that prior to trial. Both Stephen and Betsy urged this court to not proceed with trial. They made their wishes known, and those wishes were rejected. So now at sentencing, there is this opportunity for Mr. Stano to give some grace and deference to the victim for the suffering that they have endured in the last nearly 3.5 years. And unfortunately, that opportunity is rejected. Just the idea that they would simply ask this court to impose the minimum sentence and not run the tampering charge consecutive The fact that that is ignored and the wishes of the victims are trampled upon yet again, I find appalling. So I would ask the court to impose the mandatory minimum 15 years to life. And I would also indicate what Mr. Laybourne said, and you have a number of letters from people in the community. It's easy for Mr. Stano to reference anonymous people in the community who don't want to be heard, who don't put their name to a letter, who don't come into court and testify. I've gotten dozens of emails full of rage and vitriol and hate and anger from anonymous members of the community that want to see Sydney receive the death penalty. That's not what we listen to. The Constitution demands and compels that we listen to the people who are most affected by this crime, and those are the individuals back here in this courtroom. That's who Mr. Stano should be listening to. He should have also read the letters that I submitted from the members of the community who were courageous enough to put their name on what they are asking this court to do. And what you saw in those letters from the community are letters from police officers, letters from a teacher, and you heard from a teacher in this trial, letters from a doctor, from lawyers, from people who work with Brenda Powell for almost 30 years. Those are the people in the community that I would urge this court to consider the opinion of, the people that know this family well. I would ask the court, as Mr. Laybourne had indicated, to do whatever you can in the journal entry to ask the Department of Corrections to consider giving Sydney a bed at the new reformatory for women mental health facility. I know that this court is very limited in what you can do, and this will be up to the Department of Corrections, but I would ask the court to consider doing that.
Prosecutors, while acknowledging the family's wishes, argued that the sentence should reflect the seriousness of the crime, including a request for additional time related to evidence tampering.
First of all, to the victims, to the family and friends, I am terribly sorry for your loss here. I cannot imagine what you have been through. I have received and read all of the letters that have been sent to me. I have considered the evidence that was brought into evidence at the trial, the statements of counsel, and all of the information that is before me at this time. I do find that counts 2 and 3 merge with count 1 for purposes of sentencing in this matter. Based upon the facts and circumstances of this case and in consideration of the relevant sentencing factors, including seriousness and recidivism, and applying the minimum sanction that the court has determined will protect the public and punish the offender without imposing an unnecessary burden on state and local resources, the court imposes the following sentence. On count 1, ma'am, I sentence you to an indefinite sentence of 15 years to life in the Ohio Department of Corrections. On count 4 of the indictment, I sentence you to 3 years in the Ohio Department of Corrections. Those 2 sentences to be run concurrent with and not consecutive to each other. Ma'am, please understand that on count 4 of the indictment, you may be subject to a period of post-release control upon your release. And if you violate that post-release control, the Adult Parole Authority is authorized to return you to prison for up to 9 months for any single violation and up to 50% of your prison sentence for all violations. Please also understand that if you're placed on post-release control and you are convicted of a new felony, in addition to being punished for that new offense, the judge could add an additional consecutive 1-year period of time in prison, whichever is greater as a maximum. Ma'am, understand that you have a right to appeal this decision, and that notice of appeal must be filed within 30 days of the sentencing judgment entry.
After considering all sides and the unique circumstances, the judge decided to merge the assault and tampering charges with the murder conviction for sentencing. Sydney Powell was sentenced to 15 years to life in prison, the minimum allowed by law, with all court costs waived. The judge also recommended she continue receiving mental health treatment while incarcerated. However, in December 2024, an appeals court overturned her conviction, ruling that the trial judge erred by not allowing her legal team to respond to the prosecution's rebuttal, a step known as surrebuttal. The court found this violated her right to a fair defense and granted her a new trial. In early 2025, prosecutors appealed the decision to the Ohio Supreme Court, arguing that the ruling could set a problematic legal precedent. The case remains ongoing. In February 2023, Becky Hill, then serving as the Colleton County Clerk of Court, became a prominent public figure during the high-profile double murder trial of Alex Murdaugh in South Carolina. However, not long after the trial concluded, allegations surfaced that Hill had improperly interacted with jurors and released sealed evidence.
I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
Right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions? What else?
To watch him closely.
To watch him closely. Anything else you remember?
There it is, but I can't remember.
Okay, that's fine. Was your verdict on March the 2nd, 2023, in any way influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right, and I understand that. That's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right. Be at ease.
Though the South Carolina Supreme Court later concluded her actions were inappropriate but did not influence the outcome, questions about her conduct continued to build. By March 2024, under increasing scrutiny, Hill resigned from her post, citing personal reasons. But the investigations didn't end with her resignation. On May 14th, 2025, Hill was arrested and charged in 2 counties with multiple offenses.
You've been charged with 2 counts of misconduct in office and obstructing justice. These penalties for these three, they're common law penalties, so it's at the judge's discretion. However, I can tell you that typically the common law crimes carry possible penalties of 0 to 10 years. Your court date is scheduled for July 18th, 2025 at 9 o'clock at the courthouse at 101 Hampton Street. And do you understand the charges and penalty? Yes, Your Honor. Okay. And I assume you're familiar with that location? So because this is a general sessions offense, you have a right to a preliminary hearing. This is a hearing that will determine if the prosecution has enough evidence to move forward with the trial. If you wish to have a preliminary hearing, you must request it within 10 days. And I'm going to send that paperwork with your packet for the preliminary hearing. If you'd like to have that, you can go ahead and sign that now, and then we'll get that scheduled. Before you can plead guilty or not guilty or proceed to trial, you need to know you have a right to an attorney. And I see that you have a private attorney here, and am I correct? It's Will Lewis?
Yes, Your Honor.
Okay, thank you. You need to know if you were an attorney at any point, you can apply for a public defender. I'm assuming you want to stick with Mr. Lewis at this point?
Sure.
Okay, what I will do, I will send the application in your packet for public defender in case things don't work out and you change your mind. So you will have that application, okay? All right. Would you please give me a good telephone number? And you know what? I think with the press, we're live streaming. I'm going to get that after so we don't have that on the live stream, okay? And I'll check with your address with that as well. You do need to know you keep your address and phone number updated with the court. You're required to notify the court if you've had any change of address until the completion of the case. Not receiving the notification due to the wrong address will not be an excuse for not attending court, and a bench warrant could be issued for your arrest and your bond revoked. You have a right to request a jury trial, and a jury trial would be judged by a jury of your peers as opposed to a bench trial with a judge. You have a right to be present at your trial, and you need to be aware the trial will proceed in your absence should you fail to attend. In a general sessions court, if you do not appear, you can be fined an additional $5,000 and 5 years in jail. If your charges are dismissed, or if you're found not guilty, if they're not crossed, you may request to have your record expunged, which means it'll be taken off your record like nothing has ever happened. Do you fully understand your rights and responsibilities I've gone over this morning? Yes.
In Colleton County, she faced 2 counts of misconduct in office and 1 count of obstruction of justice. Prosecutors alleged that she had shared sealed courtroom materials with unauthorized individuals and used her position to advance personal interests, including promoting a book she wrote about the Murdaugh case. Meanwhile, in Richland County, she was charged with perjury, accused of lying under oath about whether she allowed media to view sealed evidence. Hill turned herself in and was granted personal recognizance bonds totaling $80,000 across both counties.
Okay. At this time,
This is Adam Splzeski with SLED. Oh, Your Honor, we have no recommendation as far as bond.
okay, all right, thank you. And then, Counselor, would you like to address
Yes,
this
Your
one
Honor.
this
Will
time?
Lewis, May it please the court, and I apologize for sitting down and not standing, but speaking to the court is the only way I can get in your screen.
The cameras are a little messed up, I know. Thank you.
The position that they've taken in under 17 or 1510, we're entitled to recognizance bond on her own recognizance, absent showing that she's a danger to the community or risk of flight. She lives here. She turned herself in. We found out about these charges last night. We're here right now. So we'd be asked that she's released on her own recognizance.
All right. All right. Ms. Hill, are you currently on probation, parole, or out on bond now?
No, ma'am.
Okay. And then, how long have you lived at your address?
25 years.
Okay. All right. I do not find you to be a flight risk or danger to the community at this time. Before I set your bond, I must apply stipulations of the bond. And if you break any of these, it can result in revoking your bond, and you'd be subject to remain in jail until your case has been called to trial. Do you understand? Okay. You must appear at all your court dates. You need to keep the peace. In other words, stay out of trouble. Because I do not find you a flight risk or a danger to the community, you are entitled to a PR bond. I'm going to give you a PR bond of $10,000 per charge for a total of $30,000, and that'll do it.
At her bond hearing, the judge determined she posed no flight risk or danger to the community. Her next court dates were scheduled for July 18th in Colleton and July 25th in Richland. The fallout from her alleged misconduct continues to ripple through the legal system, not only raising concerns about her own behavior, but also fueling ongoing appeals in the Murdaugh case. Hill is also under review for 76 ethics violations, ranging from misuse of public funds to plagiarism in her published work. On a day in late November 2024, 70-year-old David Tuttle pulled into a liquor store parking lot on Metropolitan Parkway in Atlanta. Moments later, surveillance cameras captured a young man, identified as 20-year-old Dylann Mosley, approaching Tuttle's vehicle while carrying a weapon. Without any clear provocation, Mosley reportedly initiated a brief interaction, then fatally shot Tuttle. The footage showed Mosley dragging the elderly man out of the car, leaving him on the ground and driving away in the stolen vehicle. Several bystanders witnessed the attack.
Thank you, Your Honor. Mr. Mosley is a young man, 20 years old, if my math is correct, or thereabouts. He has lived in around Jonesboro his entire life. He's got, in terms of connections to the community, he has his family here, his entire family is here, his mother, his stepfather, he has a brother, sister, he has two child there. Ultimately, he has been doing largely employed with school. He's been going to Atlanta Tech, doing his GED classes there. His plan was to move forward to a trade school, potentially the military, obviously, depending on how all these things shake out. This is a situation where there should not be any risk of intimidation or threats to witnesses. Ultimately, it's my understanding that the alleged victim here was a total stranger. This took place at a liquor store, and while the liquor store is operated by family members, ultimately there's no indication of any sort of threat towards any of those family members. In fact, I think the fact of the case here is that Mr. Mosley is far from trying to run from any of this. Mr. Mosley was actually brought to the scene of the location where he was ultimately arrested by his family. So far from running, he's been coming to try to deal with this and cooperating as well as he possibly could. He has no previous convictions whatsoever.
Mosley was soon identified as the suspect and brought to the scene by family members, where he was taken into custody. He had no prior felony convictions, but authorities noted an aggravated battery case pending in Clayton County and an active hold from Harris County, Texas. On April 7, 2025, Mosley appeared virtually in court and entered a plea of not guilty.
Can you hear me now, Mr. Mosley?
Yes, ma'am.
Okay. All right, we're doing the state versus Dylann Mosley, 25 SC 00119. All parties are present via video. Mr. Mosley is going to be represented by Ms. Lake, but today he's represented by Ms. Levy and the state's represented by Ms. Robinson. First matter is a plea and arraignment, and Ms. Levy, what plea is he entering today?
And actually, Judge, this one I'm going to be handling. We did a case switch.
Oh, okay. So,
But
Mr. Horsley, hold on, Mr. Horsley, are you keeping it or just today?
Keeping it.
Okay, very good. Thank you. All right, Mr. Horsley, what plea will he be entering?
Not guilty, Your Honor.
All right, and does he waive formal arraignment?
Yes, please.
And may I sign your name to the indictment?
Yes, Your Honor.
Ms. Robinson, may I sign your name?
Yes, Your Honor.
Mr. Mosley, may I enter your not guilty for you and sign your name?
Yes, Your Honor.
His defense attorney emphasized his deep community ties, highlighting that his entire family lives locally, that he is a father, and that he had been pursuing his GED with plans for a military career.
And ultimately, we just simply are asking for the chance to have him out and assisting with the defense. So ultimately, he has all the ties to the community in the world, no previous conviction, no reason to think he would commit future felonies while out. I think he has a previous arrest out in Texas that's my understanding has been dismissed, and then there's one other, I believe, pending case out in Clayton County. Bottom line, we understand that the bond would be substantial in this sort of case, and we simply ask that a bond be put in place, even if it's $50,000, $80,000, whatever it needs to be. Ankle monitoring, obviously, we would presume would be in place in this sort of case. think that's all we need, Your Honor. Thank you.
Thank you. Ms. Roberts, may I hear his history, please?
Yes, good morning.
Good morning.
At a total of 3 cycles, he had an aggravated battery arrest out of Clayton County from December of 2022. There's no disposition listed for that case, and he has no convictions, and nothing further.
All right, thank you. Officer Acusa, do you have anything to add?
No, Your Honor.
Okay, thank you. All right, Ms. Robinson, I'll hear from you.
Thank you, Your Honor. Your Honor, the state opposes bond. This incident arises from a November 20th, 2024 incident where Mr. Mosley fatally shot Mr. Tuttle in the neck during a carjacking. This did happen at 2151 Metropolitan Parkway Southwest. There are high definition cameras that captured this incident on surveillance. This is at a liquor store, Your Honor, where you can see Mr. Mosley initiating some sort of conversation or walking up to Mr. Tuttle, who arrives at this liquor store, and moments later you hear a shot. Mr. Tuttle is dragged out of the car, and he is left there to die, and Mr. Mosley then takes his vehicle. There are several witnesses to this incident, so he is a risk to intimidate those witnesses if released on bond. He's also a danger to the community. He does have an open case out of Clayton County for aggravated battery. He also has a hold out of Harris County, Texas. So, Your Honor, the state will contend he is a multi-state offender, and he is a risk of flight and a danger to the community, Your Honor. So the state would oppose bond.
The defense argued that he was neither a flight risk nor a threat to witnesses. However, the prosecution pushed back, pointing to the violent nature of the offense, witness concerns, and Mosley's multi-state legal history. No information regarding the bond has been released. The case remains ongoing, with serious charges including murder, carjacking, and armed robbery still pending against Mosley. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.